Hi all, and welcome to our webinar today. We're just going to give everyone a couple of minutes to filter in. Lots of us will be working from home and everyone is joining online. So if anyone is up for popping where they are joining from in the chat, that would be amazing. I'm joining from Essex and it's a really lovely sunny day here. Dan and Simon, where are you joining from today?
Sunny Chester, yeah, so not too far away from Chester for me. Nice day. You, Simon, Manchester?
I'm in the middle of Manchester. Yeah, it's pretty good here.
Amazing. Someone said, oh, lots of sunny places. Amazing. Someone said they're in Margate, maybe they're by the beach. So we're just giving everyone a couple of minutes to join. Please familiarize yourself with the chat functionality and keep letting us know where you're joining from. I like that everyone seems to be prefacing where they're from with sunny. It's a bit of a shock to us here in the UK, but it's certainly lifting everyone's spirits, I think.
It's just what they need just before we go a deep dive into deepest, darkest legislation land with me and Simon. So hopefully the smiles are on everyone's faces by the end of it, Betty.
For sure. Amazing. So I think we'll start and hope that anyone else just filters in. So my name is Betty Underwood and I work here at Giant Group in the marketing department and I'll be your host for today. I'm also joined by Dan Haslam, Group Sales Director, and his role includes helping clients, both hirers and agencies, to manage their contingent workforce compliantly and cost effectively using the whole range of Giant services and products. We're also delighted to be joined today by our guest speaker, Simon Bloch, partner at JMW. Simon is co-head of the firm's employment team, having joined JMW as a partner in 2017. He has a specific expertise in working with clients in the recruitment sector and has worked with clients in this sector since 2007. He has extensive knowledge and understanding about agency workers' regulations and regulatory legislation that govern how employment agencies can operate. Simon has worked with a number of the recruitment trade associations and their members. He has significant expertise and experience in advising recruitment businesses with restrictive covenant disputes and has specific expertise in the issues arising from the use of social media. For the next 40 minutes or so, we'll update you on a number of topics related to the proposed Employment Rights Bill and the Umbrella Consultation, looking at their potential impact on recruitment businesses and the UK temporary labour market. Many in the recruitment market are not fully aware of the impact of the proposed legislation. And today we want to shed some light on what is changing and start to think about how the proposals could impact the market and what you can do now to start to prepare for these changes. We expect there to be lots of questions, so please send them via the Q&A button and we will leave 20 minutes or so at the end to address as many as we possibly can. So the topics we'll cover today include the key proposed changes to the Employment Rights Bill, specific areas that will impact the UK recruitment sector, how will the UK market react, end hirers, recruiters and suppliers, the Umbrella Consultation, what's there to know and how could this impact recruiters and hirers? And then we'll get onto the Q&A at the end. So let's begin by taking a closer look at the Employment Rights Bill and the significant changes and challenges that it may bring. So, hi Simon, please could you start by running us through the proposed bill? What are the most significant changes in the bill and how do they differ from current legislation?
Yeah, thanks for that. So the bill was introduced to the House of Commons on the 10th of October 2024. If you recall, when the Labour Party got into power, they had issued a document, the Plan to Make Work Pay, and what they described as the New Deal. And what they promised was that they would introduce legislation or this bill within 100 days of getting to power, and they delivered on that. So the bill has been making its way through the House of Commons over the course of the the last few months. It received its second reading in the House of Commons on the 21st of October, and it went through the reporting stage in the House of Commons on the 11th and the 12th of March. The current status of the bill is it's now at the stage of progressing through the House of Lords over the coming months. What we expect to see is, unless there are any significant amendments that are proposed by the House of Lords, that by the summer, and probably before the summer recess, I think that's a good educated guess. Remember, I don't have all the predictions as to what the House of Lords and how they're going to react to it. So it's all a little bit of guesswork, and what the guesswork of commentators is as well. We'll expect that by the time of that summer recess, this bill will become law. And although we've got the bill, there is going to have to be vast swathes of regulation and statutory instruments that will bring and give effect to how this piece of legislation actually works in practice. So what we've got at the minute is we've got the nuts and bolts of what the government are proposing to do, but we don't have actually all the specifics, and there's going to have to be a lot more detail that is provided in relation to how the laws will work. But I think what we can safely say is if the bill goes through by the summer, I expect that some of this will become law as soon as October 2025. So that's the time frame. What I'll just try and have a brief look at with you is what some of the most significant changes are in terms of just some of the headlines of how it works and the changes that are being brought about. So the first thing I just want to talk about is day one unfair dismissal right. So if you understand how the law currently works, if you're an employee and you're hiring, the employee currently needs 2 years qualifying service before they've got any entitlement to claim for unfair dismissal. That's quite an important factor in terms of when you hire somebody, because you realise you've got a period to see how it's working, whereas before you have to decide whether or not you want to retain that person. If performance isn't good, if market conditions aren't working out particularly well for you, and you've decided, well, I just need to let that person go. That's how the law currently works. What the Employment Rights Bill is going to do is going to introduce a new right not to be unfairly dismissed from day one, which is a huge change in the legislation, because that's going to potentially already affect your hiring practices now in terms of the people that you're bringing in. So if you think about it, if you want to get rid of somebody for underperformance once the new legislation comes in, you're going to have to realise that if you don't do what the legislation says, then you could be staring down the barrel of a potential unfair dismissal claim. There are two things that I just want to say in relation to the new right not to be unfairly dismissed. Is it will be subject to an initial period that's defined in the proposed legislation, which is effectively a statutory probationary period of employment. So there will be a statutory probationary period which will be set by the legislation. And during that period, you can have a lighter touch dismissal process that is not that can be used by an employer. And although it's not yet confirmed, the government has expressed an interest for this period to be a 9-month period. But that will be subject to further consultation. So if you think about what that looks like, if you want to undertake a process to terminate an employee, the likelihood is the very least that you're going to need to do is to have a meeting with the employee probably attended by a representative or a colleague. And you're going to have to be a lot more conscientious and reasonable in terminating that individual's employment. And although it's not confirmed by the legislation, no doubt communicating that as a follow-up, but because you're going to have difficulties in people who don't show up, and making sure that you've got a good record of what was said and the reasons for that to avoid the potential unfair dismissal claim. What's it going to do? Is it going to make people's hiring procedures more robust? I would say so. The moment you've got a lot of flexibility in terms of deciding who you bring in terms of making sure that the person is the right fit for the job. Whereas if you're facing and you're running up against these new processes, you're going to want to make sure that is exactly right so as to avoid these potential risks. And some of the other thing that is inevitable that you may get here is that as regards the job that a hirer may have decided to take on permanently, they may decide that they want to use a more temporary form of labour, albeit that's still not an easy path, as we'll explain in a moment. Some people may want to not take on permanent people and may want to take on a temporary labour. There's also going to be some consultation. Can everybody hear all right? Because some people said that they can't hear down the side.
We've checked. I think it's a personal issue for a couple of people,
Okay,
but
no
I think
problem.
in general, yeah.
Okay. In terms of compensation, there are currently laws in relation to how compensation is assessed. There will be consultation that goes forward as to whether these light to touch dismissal procedures attract the same level as compensation as ordinary unfair dismissal claims. So that's a huge change that's going to come about and will need some thinking about. The next change, which is significant, is eligibility for statutory sick pay. So that's been expanded to include low wage workers who earn less than £123 a week. At the moment, how the law works is that there are lower earnings limits, whereas if you don't earn that lower earnings limit, you're absolutely not entitled to statutory sick pay. You may be entitled to other benefits, but you're not entitled to receive statutory sick pay. And it's now been confirmed following consultation that eligible employees will receive 80% of their average weekly earnings, or the standard SSP rate, which is rising to £118.75 from April, and it's the 1st of April today, and whichever is the lower. The other thing that's significantly changing in relation to SSP is that the 3-day waiting period is going. So people will be entitled to SSP from day one, which presents with it a whole host of problems in terms of, I've had questions thrown at me in relation to this. What happens if somebody does not show up on day one? Are they entitled to SSP? Question mark. On the face of this legislation, yes, they absolutely are. They say that they're sick, that they're entitled to SSP because there is no qualifying period. In terms of 0 hours contracts and agency workers, I'm going to cover this in a little bit more detail as we go through. But there will be a right for workers who satisfy certain conditions to be offered guaranteed hours at the end of the relevant reference period that reflects the hours that they've worked, and the right for workers to be given reasonable notice of shifts and changes in shifts. And there is going to be rights to payments each time a shift is cancelled, moved, or curtailed. So that is a huge topic that I'm going to just talk about a little bit more later on. I think that's worth pointing out there is that when the government started to talk about 0 hours contracts, they talked about it from the perspective of ending exploitative 0 hours contracts. And I think it's important that we try and underscore the meaning of the word exploitative, because through the consultation, through the process of this bill passing through legislation, there was some debate as to whether or not agency workers were going to fall within the scope of the legislation, and they certainly are. Agency workers that all agencies supply are well within this legislation, and that is a huge change to the temporary working regime that we have all been used to for so long, that agencies are able to supply flexible contract labour, and the nature of the work is such that they could be cancelled or curtailed at short notice. But this government have decided that that is not the right thing going forward in terms of ensuring people are protected. So that will be a huge change that we have to grapple with. In relation to umbrella companies, the definition of umbrella companies is going to change. It will be brought within the definition of an employment business. There has been no legal definition of what an umbrella company is. There's no defined term anywhere within legislation. So this is part of trying to ensure that umbrella companies are regulated. And also we've got the Fair Work Agency enforcement. So the Fair Work Agency is state enforcement that will be created by the bill, and it will comprise of existing enforcement functions, including national minimum wage, statutory sick pay enforcement, modern slavery and labour exploitation, as well as holiday pay enforcement. And what the government has said about this Fair Work Agency is that they will be there to enforce failures to adequately record holiday pay, enforce the failure to pay workers certain statutory payments, including sick pay and holiday pay, and also to bring employment tribunal proceedings on behalf of workers where they have the right to, but it appears that they are not going to do so. So I'll talk about that in a little bit more detail as well. And also they are going to be able to recover enforcement costs that have been incurred by the Secretary of State from employers who failed to comply with the law. So I've just touched on probably maybe 4 or 5 of the biggest changes, but the Employment Rights Bill totaled around 28 changes. I will focus on the main ones, but you can see that this bill that is quietly-ish progressing through the Parliament is going to have far-reaching effects. I don't underestimate how a significant change this is going to make to how people work and the rights that people have, because this isn't something that people are going to be able to prepare for by just having a quick read of it a few days before it comes into practice. It's going to require some thought, which is why people such as Giant are talking to you about it well in advance so that preparations can be made.
Amazing. Thanks, Simon. So there's a lot that the government are proposing to change here. I know you touched on it a little bit at the beginning, but are there any proposed timelines for the implementation of these changes?
Yeah, I think the best that we can say at the minute is that the government has said that they're going to consult on the majority of the proposed reforms this year. So we've already had consultations that were running from October 2024, and responses were produced in March in relation to a number of topics. But in terms of these changes that are going to go through once the bill becomes law, the government has said we are going to consult with stakeholders, and if more time is needed, we'll get more time. They'll consider that. I think the way that I look at this, and it is a little bit, it's still guesswork, is that some of the changes will come into force from October 2025, the ones that are more simplistic. The majority of the changes will come into force in 2026, and there are still some that will come into force in 2027. So in terms of, although it's not one of the changes that I've talked about in any great detail here, the talk about increasing the time limit for employment tribunal claims from 3 months to 6 months could come into effect as quickly as October 2025. Some of the trade union laws will come into force probably in 2025. Some of the friendly changes will come into force in 2025. And also the prohibition on dismissing employees for refusing to change terms and conditions, the fire and rehire changes could be enforced in 2025. But in terms of some of the biggest ones that I've talked to you about, the day one unfair dismissal rights, day one SSP and removal of the lower earnings limit, and the talk is that they may not come into force until 2026.
Okay, amazing. Thank you for that. Just a quick reminder to the audience, please submit your questions using the Q&A function rather than the chat, just because it means that we can get back to anyone afterwards, if need be, if we don't get around to them. And then continuing on, Simon, we understand that there are some nuances here, depending on how workers are engaged. So could you please talk us through how these legislative changes will affect temporary, contract, and then agency workers?
Yeah, so I talked about at the beginning about 0 hours contracts being potentially exploitative, and the government wanting to end the one-sided flexibility that 0 hours contracts provided. During the consultation, there was a significant debate as to whether or not an agency worker would fall into the provisions in relation to the banning of 0 hours contracts, or the prevention of them being exploitative. And it's now come down into in favor of those agency workers being included within the 0 hour contract reform. So the bill now will extend the entitlement to a contract which for qualifying workers, which reflects the hours that they regularly work, to agency workers. And the bill will therefore place an obligation on end hirers to offer guaranteed hours to qualifying agency workers. So just to repeat that, the bill will place the obligation on the end hirer to offer the guaranteed hours to the qualifying agency workers. They are considered to be the best place to forecast and manage the flow of future work, and therefore the government decided that they should control it. But the bill will also include provisions that will place the responsibility on the agency or other entities in certain circumstances, but it's not clear on when those circumstances may yet arise. We'll have to wait to see what detail is thrown up about that. So the provisions within the bill will still permit hirers to offer temporary contracts where there is a genuine temporary work need, such as seasonal demand. And the bill also includes provisions to address scenarios where end clients require the engagement of an agency worker on a temporary basis, where it has, acting reasonably, requested that the agency stop supplying the worker for reasons such as their capability or conduct. So that's the starting position. Then we move on to reasonable notice of shifts or cancellation or changes. So the responsibility for providing agency workers with reasonable notice of shifts, shift cancellation and changes will be both on the employment agency and the end hirer. So this is an extension of the existing provisions regarding how I would describe joint liability within the agency workers legislation. And what is deemed to be reasonable notice has still not been confirmed and will be likely to be debated within the further consultation. Within the consultation, what the government has said and acknowledged that there are circumstances in which short notice may be considered to be reasonable, but it will need to be defined within secondary legislation. And then we move on to the payment for shifts that are cancelled, moved or curtailed at short notice. So the bill further stipulates that the responsibility to pay agency workers for short notice shift cancellations or curtailment payments will be placed on the employment business. And what the government believes is that this is going to be the most efficient approach on the basis that workers will already be on the payroll for the agency, and employment businesses will be entitled to recover an amount from the end hirer, which reflects its responsibility for the shift being cancelled, moved or curtailed at short notice. But it will only be possible where the arrangement between the employment agency and the hirer was entered into a date 2 months after the bill is passed and remains unmodified. So that's a huge change in relation to how it's going to operate in relation to the supply of agency workers, and who will be covered by that, because they've taken, no doubt, a lot of sounding lessons from how the agency workers regulations has worked in the past, and they've tried to develop a system which ensures that agency workers are not considered to be totally flexible labour where they've worked for certain set periods of time, and they should be guaranteed certain set hours effectively. So that's how it will work in relation to agency workers and 0 hours contracts. Then we've got the bill amending the definition to include umbrella companies within the definition that already exists within the conduct regulations for employment businesses, which means that umbrella companies will be regulated by the Employment Agency Standards Inspectorate and ultimately by the Fair Work Agency in terms of their practices. The idea being is that with some umbrella companies, their practices have been under some sharp scrutiny for some time, and this is considered to be a way to make sure that they are regulated. I know Dan will come on in a little bit to talk about the responsibility for accounting for PAYE and NICs for umbrella companies moving. So I'll let Dan tackle that in a little bit. Then we've also got the Fair Work Agency, which I'll just expand on in a little bit, because it's really quite important in terms of how it's going to work. So the bill creates a new state enforcement agency called the Fair Work Agency. It brings together existing enforcement functions, such as for minimum wage and statutory sick pay enforcement, labour exploitation, modern slavery, and also adds holiday pay enforcement. And what the Fair Work Agency will do is it will enforce failure to keep adequate records of holiday pay. And the amendments to the bill that were passed showed that a new obligation would be provided to require employers to keep records demonstrating their compliance with holiday entitlement. That includes the amount of leave and the pay. There's no set format that you're going to need for those records, but they must be kept for a period of 6 years. And failure to comply with those requirements will be punishable by a criminal offence with potentially unlimited fines. The Fair Work Agency will also enforce the failure to pay certain statutory payments to workers, including holiday pay and statutory sick pay. If you think about this, the holiday pay rules were made more understandable for agencies and umbrellas last year, and now we're moving towards a way to make sure that people are not doing underhand things in relation to holiday pay and statutory sick pay. So that's why this Fair Work Agency is going to want to take control of this particular area. And what the Fair Work Agency can do is that they can issue a notice of underpayment to employers, which specifies the amount that's payable within 28 days. And that, combined with a penalty of up to 200% of the sum due, which is payable to the Secretary of State. That has similar hallmarks to how it works in relation in relation to national minimum wage compliance. So getting holiday pay wrong now could have significant repercussions once the Fair Work Agency comes into operation. And in relation to bringing employment tribunal proceedings, if the worker has the right to bring a claim, but it appears that they're not going to do that because it requires effort on the part of the worker to bring that claim, then the Fair Work Agency will now have the power to provide the legal assistance for employment tribunal related proceedings. And finally, as I said, that they will also be able to recover enforcement costs that are incurred by the Secretary of State for employers who are not complying with the law. And so the methodology of that will be set out in future regulations. So that's a run through of how those changes are going to work in a bit more in practice and how they're going to affect those people who are working in the temporary contracting sector. So you can see there's quite a lot to contend with.
Amazing. Thank you, Simon. You also wanted to highlight what's not currently in the draft bill and what we could expect further down the line. So could you let the audience know what other policies could be looked at in the future?
So anybody who was keeping an eye on Labour's New Deal will see that there was quite a lot of stuff in there that was talked about and which I've not made any mention of today. And I want to just focus on a couple of those because they got quite a bit of attention. The first one was the right to switch off. So it was initially announced by the government that it was going to introduce this right to switch off for workers, which included the right not to be contacted by their employers outside of their working hours. The government also suggested introducing rights to protect workers from remote surveillance, but that's been removed and is no longer forming part of the proposals within the bill. They were trying to replicate systems that are used in some countries, but I think they've realized that, especially in the economic climate that we're currently faced, but by introducing this provision, that they were going to make it quite difficult if they were going to say workers can't be contacted at all outside of their working hours. So that's gone. The other thing that the New Deal talked about was this single worker status, which, if you understand how employment law works, there are three statuses in employment law: people who are employed, who have the greatest amount of employment rights; workers, which is the hybrid category, which has limited amount of employment rights, but have protections, things like working time regulations, discrimination law protections, whistleblowing protections; and finally, those who are genuinely self-employed, who have the most limited amount of rights. What the government had proposed was to introduce a single worker status for everybody who was not genuinely self-employed would fall into this category of being a worker. And that would have afforded all workers potentially the same rights and protections, including the right to the same statutory payments and family-related leave, but that has been dropped from the proposals within the bill. I think all I can say in relation to that is it's something that the law does need to grapple with, but I think Labour have decided that we need to be careful how much we bite off at the minute. This is a huge thing that we would need to do, and we'll perhaps look at it further down the line, subject to what happens in a further general election.
Amazing, thanks, Simon. So from reviewing the consultations, what new compliance obligations will recruitment agencies specifically need to be preparing for?
Yeah, so I think in terms of the 0 hours and agency workers, the bill is now going to place the responsibility on employment agencies to give workers reasonable notice of shifts, cancellations and changes. And whilst reasonable hasn't been confirmed, employment businesses are going to need to ensure that they have adequate processes in place to ensure that workers are given sufficient notice. How that's going to work in practice, what the systems are going to look like to ensure that you've got a good way of tracking it and preparing for it. So if you have good systems in place, it will help reduce the number of circumstances in which employment agencies are required to have to unnecessarily pay workers for short notice shift changes and cancellations. The responsibility to pay agency workers for short notice shift cancellations, changes or curtailment payments are going to fall to the employment business, and therefore employment businesses are going to need to ensure that they have the correct processes in place to comply with that requirement to avoid potential claims. And I can see claims coming. I can see this being one of those new television adverts where people will say, have you been affected by this? Please contact us. We'll be able to help you with a claim. So you're going to want to make sure that you've got a good system in place to avoid having to make payments out. I'll leave the umbrella companies bit because I think Dan can put a bit more on that when we get to it. In terms of the Fair Work Agency, employment agencies are going to have to make sure that they've got their holiday pay records absolutely in order. And whatever systems that they've got to make sure that they've got compliance sorted, you're going to have to make sure that you have good systems in place. I keep talking about systems, planning and preparation. People are going to get quite bored of those words over the course of the next year or so, but it really is true. Planning, preparation, systems, educating managers are going to be absolutely key to getting this right.
Amazing. Thank you, Simon. Dan, if I could now bring you in here. Based on the changes that Simon has covered, how do you see the market reacting to these changes, and what conversations are you having with agencies and hirers on this topic?
Yeah, thanks, Betty. I think it's been a little bit of a battle at the moment to get the impact of the Employment Rights Bill onto the agenda of a number of different agencies. But I think, in fairness, most businesses have really been trying to digest and process the impact of the employers' NI increases, which obviously come into effect from next week. So that's really been chewing up a lot of time between agencies and hirers as they sort of work through the implications there. But I think the Employment Rights Bill is now just starting to be looked at. Obviously, as Simon's mentioned, there's a number of things that could come in quickly, and then there's a number of areas where the consultations are probably going to push out the impact into sort of 2026 and potentially beyond. And in fairness, most agencies right now, what they're focused on is trying to drive revenue. It's obviously a tough economic climate, so they're really focused on the day job. But I think those that are forward thinking and understanding of what the legislative impact could be on the market will stand in good stead to get positioned and hopefully be able to pick up those additional revenues. I think clearly for those that have heard there what Simon's gone through, for anyone who's involved in temporary labour, it's going to be concerning because a number of those measures, in effect, when you boil it down, are effectively going to need to be priced into a supply chain. and that needs to be digested and understood, and those prices need to be fed in. But as we all know, it's an extremely tight labour market as it currently stands, and so inevitably, that's going to add some commercial pressures into the mix. I think in a lot of ways, the government should be praised for what they're looking at trying to achieve. The policies are trying to level up the rights for workers. Obviously, from a worker's perspective, is going to be welcomed. Although, again, from what Simon mentioned, these legislative changes are often taken from a position of low-paid workers who are being exploited in markets. But of course, these impacts have an impact for everybody, whether you're £1,000 a day IT contractor or somebody who's working on national minimum wage. So the impacts need to be sort of worked through. But I also think there's an area for the government to consider that there are a number of workers who do like to work on that flexible basis. There's a reason why the gig economy has really bloomed and continues to grow substantially. And a lot of that is about the flexibility and people's ability to be able to earn side hustles, or however you want to describe it. So trying to bring some balance into that where we can. I think my other conversations that I've had is people's observations that outsourcing potentially will remain attractive to companies who want to outsource workers over to companies like Giant and other umbrella companies. Potentially, we'll obviously come on shortly into the Umbrella Consultation, which brings some risks along with it as well. But the Employment Rights Bill coming along with all these enhanced responsibilities often leads a bit more weight to recruitment businesses and hirers actually wanting that to be managed by another party. And of course, umbrella companies have been employing workers for years as opposed to having them on worker contracts. So we're already quite used to carrying these obligations and these employment burdens. I think there's a risk also on that outsourcing point that for some roles, they could potentially be lost from the UK if companies are looking at trying to keep a lean labour force and tap into those international talent pools, then where roles can be done on a remote basis. There's certainly conversations taking place where businesses are exploring that and how can they sort of mitigate cost around that as well. And that's obviously a concern, because once those roles leave the UK, they're often difficult to pull back in. But I think certainly, like I said, from a payroll supplier perspective, I think a lot of the Employment Rights Bill pieces and those additional risks probably in a strange way actually increases the popularity of companies that can outsource and take on that risk, such as umbrella companies. So it'll be interesting to see how that sort of plays out in the market over the next 12 months.
Amazing. Thanks, Dan. Simon, coming back to you, do you have any views here on how the market might react once they've digested these changes? I think you're on mute, Simon, sorry.
Sorry about that. It's very clear that the bill is very employee worker friendly. That's no surprise with the Labour Party having brought these changes in, and it's going to provide for a huge increase administrative responsibility on the employer to prepare for and manage the changes that are going to come into effect. I think the biggest thing for any agency to have to grapple with is these changes in relation to 0 hours contracts and making sure that there is a good process that is available to follow. I can interpret the law, but I don't work in each one of your businesses as to how labour is used. And therefore there isn't going to be one size that fits all. So I can't just say, here you go, that this is a solution that might work for you. It's just going to need to go back to the absolute bare process as to how you supply agency labour and work out where am I exposed and how do I work this in relation to meeting my client's obligations. So it's preparation and managing how the changes. Also, the bill will affect the way in which the market currently operates. So and therefore, employers and employment businesses need to consider how those practices can be adapted to comply with the new legislation. I've had questions in the past about whether we can just opt out of these changes. That's just not going to happen. Or whether agency workers can opt out. That's just not going to happen, in my opinion. This is there to designed to be available to protect the interests of the workers. And like Dan was saying, many people choose to work like this because it suits their life. And if you think about what I said at the beginning, the idea was to prevent exploitative 0 hours contracts. That doesn't apply to everybody because some people choose that they want to work like this, but that's not how it's going to operate. Also, it will require employment businesses to revisit and potentially update their policies and contracts to ensure that they're being compliant with the changes that the legislation will bring into effect. So I think that's the sort of things that the market are going to have to deal with as we go through the process and the bill becoming legislation.
Okay, thanks so much both. So let's now move on to the umbrella consultation and try to help the audience understand how this is shaping up and the impact that this could have on recruiters and hirers. So Dan, please can you outline the proposals and the timescales that are involved in this?
Yeah, and I'll try and move through pace. I'm conscious of time here. We want to definitely try and get into the questions that we've got coming through. So in essence, the government have had a consultation open for a long period of time. It was actually started by the previous government, and all of a sudden, the new government really took that consultation on, reviewed the three options that were proposed within the consultation, have firmly now landed on the option known as option 3, which is effectively making a recruitment business or an end hirer who engages with an umbrella company. In the scenario where that umbrella company hasn't deducted the right levels of tax, then that liability would fall upon that recruitment agency or the end hirer if the end hirer was contracting with the umbrella directly. So moving the risk up the supply chain, which I think is a common theme that we've seen recently from HMRC and how they want to sort of drive changes of behaviour in the market. Now, the reason that this has come about is because HMRC are frustrated about the non-compliant behaviour that can happen in the umbrella market. But what I've said on this, and I've said regularly, is that we see very little of that non-compliant behaviour in the marketplace that Giant operates in, which is often white-collar, higher-paid type roles. This non-compliant behaviour, which happens at scale, happens in particular markets often. So I'm thinking healthcare markets, medical, logistics, warehousing, somewhere of these lower-paid environments. But the legislation that's coming through has an impact across the entire industry. So there's been a lot of lobbying going on between trade associations like FCSA. Indeed, Giant contributed to the consultation, and we're having meetings with HMRC as well around how in practical terms is this legislation going to be enforced, and if the risk is going to sit upon the recruitment agency, then how in practical terms is payroll going to work from April of next year. So a reminder to everybody, this is one of the measures that will come in sooner rather than later. From April 2026 is when the liability will shift up to the recruitment agency. So based on the conversations that we're having with HMRC now, it's really trying to propose to them a workable solution to make option 3 palatable for everyone in the supply chain without causing too much disruption. And in essence, it boils down to two sort of key areas. Will the recruitment agencies still be able to make a gross payment to an umbrella or payroll company if they choose to do so? And if that is the case, and we think at the moment HMRC are leaning towards that is acceptable, whose PAYE reference then needs to be used to remit the taxes that are due? Now, at the moment, you pay a gross payment through to an umbrella company. The tax is processed and then paid underneath the tax residence of the umbrella. in the initial parts of the conversations taking place with HMRC, there was a feeling that they're actually thinking about transferring that and making it the responsibility of the agency and for the tax to be remitted on the agency's PAYE reference. That is a complex change and has lots and lots of different complexities around it, which we haven't got time to explore today. But what's happening now from a lobbying perspective is trying to explain to HMRC the downsides of doing that and disruption around it, and the upsides of allowing the recruitment businesses to and the hirers to engage with an umbrella, let the umbrella company's PAYE be used, and in the scenario where tax has been underpaid, then yes, that liability would sit with that party. So we need to wait to see probably until June or July as to exactly what the draft legislation is going to shape up and say. Well, I am quite encouraged by what we saw in the consultation update last month, in the sense that it seems HMRC are recognising that there are some challenges around their initial position and are slowly sort of moving. But, you know, let's not get too excited about that. We'll need to see what comes out in June, around June, July time in the draft legislation. But I think what's clear is that the risk is going to sit further up the supply chain. It's worth bearing in mind where businesses use managed service providers to manage that recruitment supply chain. Currently, they're saying that the risk will sit with the agency closest to the hirer. So in an MSP arrangement where you've got multiple agencies, that risk is going to aggregate to that MSP. And from the conversations that we're having with those MSP businesses, they are certainly concerned because that is a lot of tax liability. Now, in a lot of those supply chains, there's already good compliant practice taking place. There's audits that take place to try and ensure that the right types of payroll companies are involved in that supply chain. But what this legislation will do is just make that real for everybody, because the risk is there, and it'll need to be addressed. So I think in terms of how conversations are going now, it's really about agencies wanting to understand, okay, how can this work in practical terms? You know, we've got solutions that we can go through for each of the scenarios that potentially are the outcome here. So there'll be a workable solution. Some are just more complex than others in terms of data and payroll transfer, as we've spoken about. I think there's certainly going to be a consolidation of a lot of PSLs now. I think where recruitment businesses have PSLs in place, they'll be enforced. They'll be a lot less likely to be looking at engaging with umbrellas as a sort of one-offs for contractors, where the contractor's asking to be payrolled through a certain partner. So we'll need to see how that will sort of play out in the market. And if there is going to be a shift in workers, if workers are going to move around from different companies, then of course that's a heck of a lot of work for businesses to go through. So I think we're all poised to wait and see how that legislation plays out in June and July time. But then we really need to get a move on in thinking through, okay, how do we now get our ducks in order? And certainly from our perspective, we're getting many, many requests now for agencies wanting to engage with us to see how we might be able to support, and happy to sort of pick up those conversations. But I think in the interests of time, Betty, we probably want to try and wrap up and flick onto Q&A, because Simon and I could go for another hour based on the number of questions that are coming in. But what I would say is, for any that we don't get round to, we'll take some time to review those and we'll send some comments out on follow-up. So thanks, and keep the questions coming in.
Absolutely. Thank you for that. And I will start to put some questions to you from the function. Just to let everyone know, there absolutely will be a recording sent out to all of you tomorrow. That's a common question that we've got. So the first question we've got is, how would an agency be able to check if the umbrella company has paid all tax correctly for all workers, please?
So I'm happy to take that one on. So there's a few different ways that can be done. In fact, it's actually already happening in a lot of situations. So we regularly receive requests from recruitment businesses to see RTI statements that we produce, which is confirmation of tax that's been remitted to HMRC, wage slips, etc. But of course, the challenge back to that can be, well, you're producing an RTI statement on an Excel, but that could just be fabricated, which is true, it could. There's pay slipping check technology that's out there now. which probably will get some renewed interest, I think, as we move through into next year, which does real-time checks of payroll as it's processed, where they're looking at the wage slip, they're looking at the funds remitted and the RTI statements, which I think is an interesting space. But ultimately, it could be the case, dependent upon how the HMRC set things out, that there'll be some form of managed payroll that's being processed here, where a recruitment business is sending data to a payroll company to run calculations, and then it's a question of, well, who remits the tax and who pays. So there's quite a few different unknowns, but we would like to think, I think, after being in the market for 30 years and with the businesses that we have relationships with, there's a recognition that not all umbrella companies are bad. In fact, there are some super umbrella companies out there, many of which are fundamental suppliers to the UK recruitment market, and I think that will continue. Having assurance around that is tricky, and at the very least, you should probably be looking for indemnities on that tax risk and making sure that you're getting an indemnity from a business with a balance sheet big enough to support that indemnity as well.
Amazing, thanks for that. The next question I've got is, do we know whether an end client's obligation to offer the hours will move the contractor assignment across to be engaged via their end client rather than their agency?
Tricky
I don't
one.
think we've got the extent of the full detail on that, really.
Okay.
At the moment.
Okay, perfect. So it's something we can definitely come back to. Quite a lot of the questions we have are very specific. So what I'd say is that our team will 100% come back to you on some of these questions and talk through your business.
I'm happy to pick out a couple of them.
We can pick out a few of them.
Scroll through, yeah. There's one here that said, "Won't this kill the umbrella market?" Which I think's an interesting question. I hope it does kill the umbrella market in the sense of the non-compliant umbrella market, because that's really what this is driving at and aimed at. I genuinely don't think that it will kill the umbrella market, because certainly in the conversations I've been having, recruiters, with all the employment rights bills detail that's coming down the track, they want to focus on search and selection. They don't want to focus on tax and employment risk. They're happy to outsource that as long as they're outsourcing it to a partner that they can be assured on is running compliantly. So I don't see that changing in essence. I think where it may get complicated, then I think that probably plays to the larger organisations that have got good software capability to cope. But I'm not panicking that this is the end. In fact, I think it's more likely that it should open up other parts of the temp labour market that have previously been dominated by non-compliant providers, and that landscape may change.
Yeah, there's a few questions
Amazing.
in there. Will a temp worker receive sick pay and pension? Well, it's a bit of a complex answer, but the short answer is that agency workers who are categorised as employed earners and meet other qualifying conditions are eligible for SSP. This change to legislation doesn't affect who will be entitled to claim SSP. It provides some protections as to the fact that SSP will be available from day one, and also whether the amount that they'll be able to claim, and whether it's the bare minimum or whether it's 80% of their qualifying earnings. Also, as I explained, is that those people who earn near the lower earnings limit, how it will impact them. So I don't think the legislation affects whether a temp will or will not receive sick pay, and by temp I mean an agency worker. Somebody's asked a question about the Fair Work Agency, about becoming the official compliance regulator to the umbrella sector rather than branded membership schemes. I think that what we will eventually see, I think the whole idea is that the Fair Work Agency will be there to bring certain things under one enforcement body. As I explained, statutory sick pay, holiday pay, minimum wage. They're the big things. You can see the theme here is that they're trying to make sure that in areas where it's exploitative, that workers aren't done out of their rights, and that the various agencies will intervene to protect those particular rights. I don't think that means that's the end of other bodies who seek about ensuring that there are good practices that go on to regulate the market. That's my own opinion of it. But it's there to make sure that certain protections are provided.
Amazing. Thank you for answering that, Simon. Just really conscious of time, because time clearly does go fast when you're talking about legislation, and we are going to actually have to wrap up for today. We will absolutely come back to many of you and